Welcome and thank you for joining us for the Name, Image, and Likeness webinar. We are excited to coach you through the playbook of endorsement agreements within the name, image, and likeness or NIL arena. This webinar will provide valuable insight so you can best approach and engage with individuals that can promote the products or services for your organization. I'm Haley Upton-Cook, Marketing Coordinator of Events and Proposals at Ward & Smith, and I'll be your moderator this afternoon. If you have any issues or video or sound quality during the presentation, please reach out via the Zoom chat feature right here. And if you have a question, please type it in the Q&A box right here, and it will be addressed at the conclusion of the presentation. I will now go ahead and turn the mic over to Clint to get us started.
Thank you, Haley. I appreciate it. Thank you for that introduction. Good afternoon, everyone. My name is Clint Cogburn. I'm an attorney with Ward & Smith out of the Asheville office. I have a background in regulatory work through my practice as a land use and land development attorney. So that really dovetails nicely into the regulatory environment that is name, image, and likeness. It is regulation and regulatory based, and we'll dive into what some of those regulations look like, how that space is being regulated. And then Erica Rogers, my law partner out of our Raleigh office, will get into some of the practical considerations, some of the contract issues or contract components that we're seeing in this space, and really dive into some of the day-to-day practical considerations after I go through kind of the regulatory environment, how the NCAA is looking at this, and talk about some of that to set up those practical considerations. But even though I have a regulatory background, the real reason I got into the NIL space is I'm an obsessive UJ football fan and UNC basketball fan. So I already spend way too much time following recruiting, scouring message boards and blogs for the latest nugget on UGA or UNC. And some may call that a waste of time, but now with NIL and the regulatory environment behind that and the need to understand some of the inner workings of college athletics and the NCAA, I've kind of had a parting of the clouds moment where all of that time spent on those recruiting message boards and websites is really paying off. And so I have a background and love for collegiate athletics, but that really leads me to my next point, which is that I'm not an expert on this by any stretch. And anybody who really tells you that they are is probably selling you a bill of goods, because this is such a new space. It is ever evolving. We are keeping up with it day to day, but the changes occur so quickly and so rapidly and really vary from state to state. And it'll be interesting to see what occurs nationally, that it makes it difficult to really keep up with it. Again, we do a very good job of it at the firm, and Eric and I work to stay on top of it all. But there really is no expert per se in this area because of the changing landscape that is NIL. So what does that mean? Well, it means that we are on the forefront of what this looks like. It also means that there's a good chance that 2 to 4 months from now, what I tell you, or at least some of what I tell you, may be out of date. I say that because while the framework and principles may endure, and we're going to provide you with tools for your consideration and use in your toolbox as you potentially get involved in NIL. And we're going to give you the tools to address what is happening here in the state of North Carolina, but throughout the country. But it is important to acknowledge, again, the changing landscape in this space. So let's dive into the substance. As Haley said, we'll be happy to address any questions that you have on this, and we will work to address those here at the end of the presentation. But really, to get started, we need to set the foundation of what name, image, and likeness is. It's a term that is thrown around regularly. It seems to be self-explaining. It seems to be very basic, but there is some confusion out there as to what it is. So everyone knows that name, image, and likeness, or NIL, stands for name, image, and likeness. But what does that really mean? Really, that goes to the individual athlete's rights to publicity and to profit and make money off of their name, image, and likeness, through advertisement, product endorsement, and business relationships. Additionally, they can make money or receive benefits through public appearances and paid promotions. Those are things like jersey sales, autograph sessions, sale of memorabilia, appearances, commercial, SponCon, which is a term that's out there that is sponsored content. Those are social media posts, and then also brand sponsorships. A lot of what you are seeing in this space, and Erica will talk about this as well, are sponsored content agreements where athletes have a significant social media presence, and in exchange for compensation pursuant to an NIL agreement, they will do certain sponsored content, certain amount of social media posts, either tagging that company, promoting a company's product, promoting that company generally. You also see a lot of the jersey sales, autograph session, memorabilia sessions, required appearances. And so you're seeing a whole bunch of different things that these athletes can do in terms of providing compensation. And Erica will get into what those types of contracts look like. If we go to the next slide, we kind of have touched on that in relation to businesses utilizing NIL with student athletes and those types of agreements. One of the things that's important to note here is that a lack of awareness as to the regulations, a lack of awareness as to the NCAA enforcement guidelines, a lack of awareness as to any federal legislation that's ultimately passed is not going to be a defense or basis to violating those provisions. And so if and when a company or individual gets involved, it's important that they know both the lay of the land at that time and where it may be going. And so that is important, and that is really the purpose of this presentation. Just to give you an idea of what the NIL space looks like currently, and some of this data is not current. But in the first year of NIL, it was estimated that just short of $1 billion was spent on NIL deals. It's safe to assume that number has ballooned even more in the past 8 to 12 months. And just so that you can go or know where to go to find that data, it is from Open Doors. And so if you feel free, or if you want to, feel free to go to Open Doors. It likely has potentially more up-to-date data. But in just the first year, you saw a $1 billion in deals, in NIL deals. And that is not going to change. Those deals have become more sophisticated. And again, Erica will touch on some of those components in her presentation. Just to dig into some of that data, over half of the NIL compensation goes to football. Men's basketball is about 22%. Women's basketball is about 11.5%. Then you have women's volleyball, baseball, softball, track and field, and gymnastics, all between 1% to 2%. In terms of what the athletes are doing, and again, Erica will get into this in more detail, a lot of it is social media posts. That accounts for about 40% of what the athletes are doing in exchange for NIL compensation. Those appearances and autograph sessions or memorabilia sessions combined to make up about 20%. And then kind of the remainder of those, or the other, is 32%. The average compensation in Division I for an NIL deal is $3,831. If you drop down to a lower division, so Division II or Division III, it's a couple $100. And so you see some of the bigger deals. You see, Bryce Young on Dr. Pepper ads. You see Armando Bacot, who does a significant amount of NIL appearances out of UNC. But really, those deals, and the average NIL deal is going to be in the $3,000, $4,000 range. So it is not a considerable sum of money. There are certainly larger deals out there, but on average, it is a couple $1,000. So in looking at where we currently sit, we want to dig into specifically what the May 2022 guidance is here, which is the NCAA guidance that really started all of this. So just to give you the timeline here, there was a lot of litigation that preceded this. There was the Ed O'Bannon litigation. There was the Alston litigation. You can go and look at those opinions, and I encourage you to do so to the extent that there are questions on what those resulted in. Happy to answer those, but there was extensive litigation for really the past decade about name, image, and likeness compensation related to video game likenesses and the like there. I'm not going to dig into those because we could do an entire webinar on just those cases. But those really set the stage for the current regulatory framework. And I encourage you to go look at the O'Bannon decision and the Alston decision, which again set kind of the foundation, the foundation for where we are today. But on July 1st, 2021, the NCAA adopted an interim name, image, and likeness policy. Then on May 9th, the NCAA Division I Board of Directors issued guidance to member institutions concerning NIL. That guidance was effective immediately and clarified the NIL environment, most specifically as it pertains to the recruitment of student athletes, which this is where NIL is largely targeted. And so that is where it is most directly applicable. And it's most directly applicable to member institutions and student athletes. This guidance is of significant importance to businesses and boosters. And it is significant as to how those businesses and boosters, which we'll go on and define here shortly, how they can support member institutions and student athletes through NIL, and what those restrictions or guardrails are on what that support is, how they can support those member institutions and student athletes, what coordination, if any, can the member institutions have with businesses and boosters in providing NIL to student athletes and prospective student athletes. Because of that, this guidance is important, and businesses need to carefully consider this guidance and ensure compliance to avoid potential pitfalls or issues. So what does this policy do? The interim policy provides the following guidance for athletes, families, and member institutions. Specifically, individuals can engage in NIL activities consistent with the law of the state where the school is located. Colleges and universities can be a resource for those state law questions. So one of the issues that has been difficult in navigating NIL is that states vary wildly in how they regulate NIL activities, and we'll get into some of that. Some allow for NIL as early as the high school level. Some prohibit it in high schools. Some are much stricter as to what NIL deals can cover. Others are more lenient and give much more leeway to those participating in NIL activities. If a college athlete attends a school in a state without an NIL law, and those are dwindling rapidly, most all states have some type of regulatory framework in place at this point. But if there is a state that does not have an NIL law, college athletes can engage in the type of activity without violating NCAA rules related to name, image, and likeness. Additionally, individuals can use professional service providers for NIL activities. So they can use things like collectives, which we'll get into here shortly. And they can also hire agents. And those typically have to be regulated in some form or fashion by both the NCAA and the state in which the school is located, or in which the athlete is located. But there are agents who are working with college athletes now for the purpose of NIL. There are requirements under that policy that student athletes should report NIL activities that are inconsistent with state law or school and conference requirements to their school. Obviously, this is a self-enforcement and kind of self-policing guidance, and it will be interesting to see how that plays out. But that is kind of the basis for that provision of the guidance. It also makes it clear, if we go to the next slide, that the NCAA bylaws remain in effect. That includes prohibitions on pay-to-play and improper recruiting inducements. However, the applicability of those prohibitions and restrictions is subject to whether an institution is in a state with or without NIL laws or executive actions. As we talked about, that is a dwindling number, but if they don't have any real framework in place, it gives more leeway and leniency and the ability to engage in broader NIL conduct compared to those that do have certain restrictions on it. The important thing to note here, though, is that the NCAA bylaws remain in effect, and that specifically and probably most importantly, NIL deals cannot be conditioned on pay for play provisions. So an NIL agreement cannot be an inducement for a student athlete to then go and attend a certain member institution, and it can't be an inducement to help in the process of recruiting a prospective student athlete to go to a certain member institution. That's why you see, and we'll talk about this here briefly, you see guardrails and walls put up between, or at least they're supposed to be put up between boosters, collectives, and coaches or employees of a member institution to really prevent or limit the possibility that there will be pay for play or recruiting inducements as part of the NIL process. So in looking at the practical effect of that May 2022 guidance for prospective student athletes, the following guidance was provided. One, recruiting conversations between an individual booster or booster entity and a prospective student athlete were prohibited. An individual booster or booster entity cannot communicate with a prospective student athlete, said athlete's family, or other affiliated individual with the prospective athlete for recruiting purposes. Additionally, an individual booster or booster entity cannot guarantee or promise an NIL agreement to a prospective student athlete contingent upon enrollment at that particular institution. And a member institution's coaches and staff are also prohibited from organizing, facilitating, or arranging meetings between a booster and a prospective student athlete. Again, all of that, it can be boiled down into there cannot be improper recruiting inducements. There cannot be a pay for play scenario where NIL is conditioned on either attending a member institution, staying at a member institution, or otherwise aiding in the recruitment to that member institution. For current student athletes, the following guidance was provided as part of that May 2022 guidance. First, it was NIL agreements between a current student athlete and a booster cannot be guaranteed or promised subject to the student athlete's continued enrollment at a particular institution. And then they also listed the same guidance we just talked about for prospective student athletes related to communications between a member institution's coaches and staff and a booster. Again, the key here is that there are restrictions on pay to play or pay to stay. So for a current student athlete, NIL agreements could not be premised on payment for that individual remaining at that institution. You'll see, and I believe Erica will talk about this, but I'll touch on this briefly. Some of the NIL agreements get around that by making residency at a specific county or city or municipality a condition of that agreement. Whether or not that could be subject to challenge, who knows? But that is a way that, at least in that environment, that they've gotten around kind of the pay to play and pay to stay, and specifically agreements premise on that by requiring somebody reside in Chapel Hill or reside in Raleigh or reside in Wake County for the duration of the agreement. Those have not been challenged. It would be interesting to see what would happen if those were challenged, but that is one of the ways that agreements are being drawn up now to kind of avoid that issue laid out in the guidance and to really avoid any violation with the bylaw. So if we go down now to, what is a booster? What is a NIL collective? We can talk about that very briefly. Really, one of the things that you have seen out of this framework and out of the NIL, the growth of NIL, is a new structure entity that was created to facilitate NIL deals, which are NIL collectives. In looking at that, according to Forbes, approximately 200 NIL collectives have been formed since NIL came about. But there's some inconsistency or misconception about what they do and don't do, how they operate, and what restrictions, if any, can be placed on them. From a baseline perspective, an NIL collective is a group of donors, alumni, or boosters, and business leaders and businesses who fund the collective. And that is kind of where we get into what is a booster. they're really those individuals that promote and make financial contributions to recruit prospective student athletes, to promote the program, to promote the success of the program. And that can be businesses, entities, individuals, et cetera. And it's those that really make those financial contributions to the program for the purpose of supporting the program and the program's activities. A lot of those are done through athletic associations that are separate and independent from member institutions. Some of those are directly to the member institution. A lot of times those are set up as athletic associations to create some benefits associated with the separation from the member institution, but really someone who makes that financial contribution or makes some type of monetary contribution to the program. If we go to the next slide, we can get into additional aspects of the booster, and if we'll skip one more ahead, and most specifically those collectives, which are really at the forefront of the NIL space here. Like I was saying, that's a new structure or entity that was created to facilitate NIL deals. You have about 200 of those collectives, according to Forbes. My guess is that number has grown, although we have seen some consolidation recently. And a lot of those are aligned specifically with member institutions. And so from a baseline perspective, like I said, an NIL collective is that group of donors, alumni, boosters, business leaders, and businesses who fund the collective as a way to provide NIL resources and opportunities to college athletes at a particular institution. The collective serves to facilitate those NIL opportunities and for those college athletes, and also help to kind of navigate the NCAA regulatory environment. Specifically, a collective is often a 501c3 organization. Though some are for-profit companies, usually structured as LLCs. Generally, those collectives pool money together, and we'll go through some of those typical forms of NIL collectives here on the next slide. And the NCHSAA defines those very similarly to what we've just talked about, which is a group of alumni, supporters, parents, or people who form a corporation, whether it's nonprofit or for-profit, essentially to provide NIL opportunities to student athletes, again, at a specific school. So what do the different collectives look like? They take a few forms. The first form is a donor-focused collective, which is pooling money to distribute to athletes. There's also marketplace collectives, which provide representation and facilitate those opportunities, acting as almost an athlete representative or agent, and donations to those collectives help to fund those efforts rather than going directly to the athletes. You have fan subscription models, which are kind of the booster club model. They're donations in exchange for points or priority. The higher priority, the more access you have to players, specifically at different events or different signings. And then you also have business partner models, which are direct fundraising with subscription-like benefits. Larger sponsorship obviously equates to more access to those players and priorities at different events or appearances and the like. You also have hybrid collectives that will take on a couple of those forms, but that's how they are typically set up. Again, a lot of these are 501c3s, some of them are for-profit, but you see a lot of different forms coming up. And again, with this being so new, it will be interesting to see how the IRS and federal government scrutinizes these, specifically over the 501c3 NILs. But it is interesting to see how different groups have been created in forming these entities to facilitate NIL. If we go to the next slide, we'll see the June 2021 interim policy guidance, which I talked about previously. We'll touch on this just briefly again. Again, the school's location determines the state law that's used. So in North Carolina, state law controls. If a state, again, doesn't ratify an NIL law, it does not preclude that student athlete from participating in NIL. It just subjects them again to the NCAA bylaws. As I said, they can use professional service providers and agents and can use other entities to facilitate those NIL deals. It's opened up sports agency to college athletes, and even some small instances to high school student athletes. And again, those student athletes do have a duty to report either member institutions or other violations of NIL policy. If we go to the next slide, it kind of talks about what those agreements are limited to. They're proper if, again, there's not an inducement, either through a recruitment or through a pay-to-play, pay-to-stay. Number two is probably the most important, which is that no pay-for-play or pay-to-stay, and it does need to comport with applicable state law. We go to the next slide. This again provides a good rundown of what I talked about, which are again the key takeaways for that 2022 guidance, the prior 2021 guidance, which again just runs down, and I won't repeat myself here, but it really is the key takeaway of no pay to play, no pay to stay. Really focus on those agreements being for certain services performed, for appearances, for that sponsored content, for autographs, for memorabilia, and not specifically inducing an athlete prospective or current from either attending or staying at that member institution. Again, there's been creative contracting here with certain requirements for residency, but these agreements cannot be premised on pay to play and pay to stay. And again, coaches and employees of the member institutions cannot be the ones facilitating that. Again, enforcement of this is incredibly difficult. I think a lot of us has probably seen it in the news that seemingly that collectives and member institutions are coordinating to some extent, but really the NCAA guidance is saying those need to be walled off. The member institution employees and the boosters cannot coordinate in executing an NIL framework. If we go to the next slide. So, like I said previously, current NIL agreements, they can't be guaranteed on remaining enrolled, and they can't be based on compensation or incentives that induce enrollment decisions or otherwise premise it on achievement of certain performances or membership on a team. So those agreements not only can't be premised on enrollment, can't be premised on somebody scoring a certain amount of points, can't be premised on getting a certain amount of rebounds per game, can't be based upon performance, and also can't be premised based upon remaining on the team. And so those are key, and those further highlight the NCAA's concern that NIL agreements will be premised on kind of the pay to play, pay to stay. Next slide, please. There was additional clarification here in October 26, 2022, which was that schools can also provide NIL education to collectives and to boosters, which is a way to really get the schools to, again, police themselves, to become aware of who is engaged in NIL. But it also then opens the door for communication between these member institution employees and coaches to have direct contact with the collectives, which the NCAA is very concerned about. If we'll go to the next slide. There's also a new NCAA bylaw, which really puts a lot of the burden on those accused of violating NIL bylaws and NIL guidance. Really what it says is that there's a presumption that a violation occurred if circumstantial information suggests that such impermissible conduct occurred. And so that's a very low bar for the NCAA to meet in issuing a notice of violation, and we'll get into those tiers here shortly. But it really is a low bar and then places a substantial burden on the member institution or employee to really rebut that presumption. And so the NCAA is putting this in place in an attempt to enforce these regulations and to try to get kind of their arms around the ever-changing and ever-expanding role of NIL. And if we go to the next slide, we can talk about the different tiers of violation really briefly. Again, this just talks about that inverted burden of proof, really puts the burden on institution, athlete, or coach And the NCAA only has to show circumstantial information, not even direct information or evidence related to a violation. And then once they do that, and if it's not rebutted, we get into kind of the tiers of violation, the potential punishment, which I believe is detailed on the next slide. And here we have the violation and structure levels put forward by the NCAA. Level 1 is the most severe. A lot of times you hear lack of institutional control, and then which can result in loss of scholarships, loss of television appearances, loss of the ability to participate in postseason play. Level 2 and level 3 are lower level violations, but that can result in certain suspensions, recruiting restrictions, etc. But you see here that the low threshold and low burden exposes member institutions, athletes, and member institution employees to potential extensive punishment as a result of that conduct. And if we'll go to the next slide. So here are the main takeaways. Again, I won't run through all of these. We've covered these extensively. But again, the regulatory environment here is looking to minimize member institution direct coordination and contact between those boosters and prospective student athletes. They're also trying to prevent the pay to play and pay to stay scenario. And it really is incumbent upon member institutions and booster organizations and collectives to ensure compliance. The NCAA is going to look to enforce this, and I would expect the NCAA will look to enforce it in the coming months and years as a way to further get their hands around NIL. And so the member institutions, booster groups, collectives, companies engaged in this space, it is important and incumbent upon those groups to ensure compliance to avoid any potential penalties. If we'll go to the next slide. Here are just some of the big deals. I will not run through these. I want to turn over to Erica. I've run a little bit over on time here, but you have Nico Iamalieva, who's a quarterback for Tennessee, who received a reported $8 million deal. You have Jaden Rashada, who had a reported $9.5 million deal and ultimately had that rescinded. You can go and Google those. I would encourage you to do so. It shows kind of the wild west that is NIL, how it's constantly changing, and how those deals can benefit a student athlete and can both harm a student athlete. Nico's is a good example of somebody who took advantage of this opportunity, and Jaden is unfortunately what can happen when good advice and good guidance is not provided to student athletes. So I encourage you to look at those. I believe I'll turn over to Erica now. Erica, thank you for letting me run a little bit over, and everyone, you're in good hands here with Erica.
Absolutely. Thanks, Clint. So now that we've set up the guidance and the framework and what we have for the regulations and laws, but the purpose of the latter half of today's webinar is really going to get into what these agreements look like. I know we have some business owners on the webinar. Appreciate you joining us. I know we have some attorneys and some other folks that might help businesses in this space. So while there are a lot of regulations and a lot of things to keep in mind, we don't want you to be intimidated in entering the space, because what this allows for is marketing opportunities, situations where previously businesses couldn't contract with student athletes to market their products and services, and now they can. And so while there are things to keep in mind to make sure that you don't run afoul to the regulations and the laws, there's really exciting opportunities here. So what I thought I would do for the second half of the webinar is to just walk through what this type of contract looks like for each of you, and also, time dependent, just go through some of the pitfalls or some of the things that you should consider as you enter, or you consider entering into one of these types of agreements. And so at the top of the agreement, usually there's who's the parties to the agreement. So if you're a business or you're an attorney with business clients and you're thinking about working with a student athlete, the main part of that agreement is going to include who the student athlete is and who the business is, and defining the terms of the agreement clearly so that everyone knows what the agreement is about. And then also at the top of the agreement is usually the term. So typically in brand ambassador agreements or endorsement agreements, it might seem like having a longer term is advantageous just to keep the relationship going, especially if it takes a minute to get what you want on paper. You might think, let's have this going forward for a while. But in the context of student athletes, the student athlete, their relevance or their commercial value is restricted by time to when they're a student of a certain school. So we'd encourage these types of agreements to be shorter for that reason, so that if you're investing the time and working with a student athlete because their identity has commercial value, if that's the goal, then you have to think about that commercial value and how long that's going to be there for you to work with them and take this risk. And so we see these types of agreements being shorter for that reason, maybe a season, a year, certainly not more than 4 years. If you're working with a freshman, and if it's a senior, more than one, but sort of thinking about the duration of the agreement when it comes to this is important, because this isn't an experienced individual that's a brand influencer. This might be a student that, is only, like I said, their commercial value is going to be time limited. So next slide, please, Haley. So the main piece and the main question here is, okay, let's say you want to do this and you have a budget and you've met a student athlete that you want to work with to promote your products or services, or maybe Clint earlier talked about memorabilia, maybe autographs, things like that. So what do you pay them and what does that look like? And that's a business decision that can be hard to make. And there are different ways that you could do it. I think probably the easiest way would be a flat fee based on certain milestones. These are students that might not have the types of support as far as accountants or things like that to go into a complicated royalty structure that you might find in another trademark license agreement. So it could be $500, per post, or $500 for the year, depending on who you're working with. You can work through some of the ways to pay them. And I would say before even offering that amount, since most of these agreements do have to do with social media posts, a lot of companies are looking at the social media pages of these athletes and their amount of followers and their amount of engagement in the way that you would any influencer, to see what amount are you willing to pay for this type of marketing service. And if they have 20,000 followers, is that going to mean more than if they have 500? And sort of working through compensation and based on what if you're making an investment as a business, you want to return. So I would say consider the amount of followers and the engagement on their social media and what your budget is for that. Remembering that, as Clint talked about earlier, the compensation cannot be tied to the school that they are attending. It can't be a way to induce them to attend a certain school. Those are both violations under the NCAA guidance. And we've also seen certain things where their payment can't be tied to the performance in the sport. And so, while you might want to pay them because they are famous or they're doing really well, things like tier payments, if they win certain games or if they score a certain amount of points, those are not going to be allowed under the NCAA rules, because that violates the pay for play type restrictions of that guidance. And so as you're considering compensation, remembering the guidance and the rules that Clint talked about can be important for that. And then finally, under compensation, just keeping note that these types of student athletes that are being that you're entering into a contract with for this type of marketing opportunity, they're independent contractors legally. Being careful about not creating an employee relationship because of some of the other issues that could come with that is an important consideration under this compensation piece as well. And there are provisions that you can include to protect the business for that. And so I'm an intellectual property attorney here. So this is the part that I think makes it, my experience dovetail well into this space, because what you're talking about is intellectual property. It's derived in rights of publicity laws, trademark laws. Why even enter into an agreement with the student athletes if there's not something of value that they're letting you use? And so their identity comes and derives from those areas. The value to their identity derives and comes from those areas of the law. And so the main thing, is the rights to their name, image, and likeness. But there are also, some athletes have certain logos or catchphrases, and in a future slide, there's some examples of that. But there's other things that can be licensed to help promote the business, and in ways that's beyond just their name, image, likeness, but certain things that consumers associate with that athlete that you might want to use as well. And when it comes to IP for these types of agreements, there are the business has its trademarks and its IP, and the student athlete as well. But you have to be really careful that in creating these opportunities for the business, you're not going to infringe upon third-party intellectual property rights. And so if a student athlete, for example, posts something on social media and they're wearing a Nike jersey, or they're carrying a can of Pepsi or something like that, and they're promoting your business, that might run afoul to a third-party intellectual property right. And so being aware of those types of issues is important for these types of agreements as well. And then, sorry, I did these out of order, but the copyright issues that could come up is when the copyright issues that could come up are when the student athlete is creating content for the business. And so that could come in the form of posts or TikTok videos or things like that. It's important in these types of agreements to consider who owns those works. So whether it be the business, if you want to retain ownership of all of that under an assignment, or if the student athlete can, but sometimes, especially going back to whether the terms are short, sometimes when these agreements expire or are terminated, there can be a dispute about who owns the videos, the posts, and things like that. So really core to these types of brand ambassador agreements or these student athlete endorsement agreements are intellectual property considerations. So Haley, if you want to go to the next slide. So this is what I was talking about as far as other trademark rights that a student athlete or even an athlete can own. So these are examples, and these are not student athletes specifically, but I thought this could give you an awareness of what we're talking about when we talk about trademark rights in this space, because aside from an athlete's name or their image, a photograph of them, or their likeness comes up in a lot of video game context. There are other trademarks that a business might want to use to promote its products or services, and that can be a part of these types of agreements as well. So here's some examples. Thank you, Haley. Next slide. So this slide kind of expands upon the earlier slide about intellectual property, in that we're getting a little bit closer to what the agreement looks like. And in this example, the pasted screenshot from a contract was a situation where an individual was allowing a company to create products using that individual's name, image, likeness rights. And so in order to do that, there has to be a provision of the contract that licenses those rights to the company so that its sale of the products are licensed. And in some of these agreements, there could also be a license back to the student athlete, because if the student athlete is allowing the business to make products or use its NIL rights to advertise its products or services, they might also want the student athlete to post on social media or use the company's IP. So the licensing can sometimes go both ways. Again, considering the risk of using the university trademarks. And so if you have a student athlete that's promoting your brand because there's commercial value to their identity, that might not mean you have, and that doesn't mean you have the right to use the university logo or the sports, the team logo or brands or things like that. And so that can involve going back to the university or finding if that's an interest in licensing those rights from the university would be necessary, separate from the agreement between the business and the student athlete. And again, considering third-party rights is important. So not just the university's rights, but is the student athlete posting a TikTok video with music and things like that, where making sure all the permissions are in place with these types of posts and the social media engagement is important, so that if a student athlete is going on social media and promoting your business and infringing a third party right, obviously you wouldn't want that to happen, or you'd want the agreement to provide protections in case it does. Next slide. We can skip this one, Haley. Okay. Another term that comes up in these agreements to keep an eye on, and also I think what I've been seeing, a lot of people like talking about these types of provisions because it can reveal the power dynamics or the leverage that's at play. Sometimes businesses want to control the type of activity that the student athlete engages in so that it doesn't come back to hurt the reputation of the business, and that's fair, that's enforceable. So certain things like if the student athlete commits a crime or certain offensive acts or certain things like this, built into the agreement should be ways that the business can get out of the agreement if something like that happens. And I think it's just the reason there's a lot of buzz in this space is making sure that there's reasonable sort of like reasonable ideas of why you would want to get out, and not overarching or not trying to control the student athlete and what's doing and what he or she is doing. But like I said, going back to crimes or specific offensive acts, that's enforceable, but not, you know, trying to control the behavior of an individual, because that wouldn't be. And then also built into morality clause sometimes are ways to have the student athlete comply with the FTC and some of the guidance that the FTC has on endorsement, and having that be a way of allowing the business to get out of these agreements if the student athlete violates the FTC's rules on what endorsement looks like, and the rules as far as disclosing that it's an advertisement and things like that. And so this is just a list of some of the other things. It wouldn't be complete to talk about these types of agreements if we didn't talk about some of the other terms that come into play. So obviously termination, and talked about that in the slide prior, that there's a provision that allows the student athlete or the business out of the agreement. And sometimes that can be just because they want to, and that's termination without cause, or it could be specific to, you know, breach or the student athlete committing a crime or things like that. But making sure that there's no situation that either side is going to be stuck into an agreement that no longer becomes a win-win situation. So exclusivity is an interesting one, because businesses usually want to make sure that if they're taking the risk and they're paying a student athlete, that student athlete isn't going to then promote the products of its competitor, and that's allowed. But having a student athlete only be able to enter into this type of agreement with a business and no other businesses, I mean, that could be overly restrictive when it comes to exclusivity, and that could actually ruin the business's reputation amongst the school or the student athletes, to then maybe prohibit their ability to work with future student athletes. So being reasonable when it comes to exclusivity is important, because of course you want to protect yourself and not have the same individual promote your competitors' products, but not being so overreaching that it's unreasonable. Confidentiality, I mean, that ties into it as well. Here's just some other standard provisions that can come in here and into the agreement. But the main thing is, it is an exciting opportunity to work with student athletes to market a business, but not having an agreement and not predicting the situations of, you know, what's going to happen if blank ahead of time. Not doing that can really set up some issues for a business that might make them think, you know, why do we do this in the first place? And so obviously having a contract in place with some of these main terms, and having an attorney help with that is the best case. And then if there's one that, you know, works really well, then having that same type of agreement be adapted for different individuals in the future can be a really good tool to see this go through multiple times with different student athletes, and rather than just a one-off. Next slide, please, Haley. And so just to summarize some of these things, the high level for the agreements, and going back to the regulations and what Clint was talking about earlier, but what can't be included in these agreements are payment for services not rendered. So just paying a student athlete because you like them or you like the school. Compensation based on how an athlete's team plays, that's the pay for play. Any sort of promise to perform services the school determines inconsistent with its values or policies. I don't think that would be an issue for anyone listening today, but certain things like you know, if a distillery wanted a student athlete to promote their vodka and that student is, you know, under 21, or even just the fact that they could be promoting it to underage drinkers, that's an example of what's going on there with what can't be included. Again, using school logos or school trademarks without permission. And as Clint mentioned earlier, the promise to stay at a certain school or transfer out, those improper recruitment type provisions, those are going to violate the NCAA guidance. And then for boosters, I know Clint talked about at the top, and yes, that is, if you're an enrolled student athlete, that's the point of a lot of point of the webinar, but that is allowed. And I added this slide for time, and it seems like we do have some time. I also want to reserve some time for questions. I don't know if anyone's asked any, but something that's really interesting in this space is the way that artificial intelligence has made it easier for fake identities and things where you know, it's very interesting from the student athlete perspective as they go and start working with businesses and they appear in more types of promotions and they're engaging more in social media. How do they protect their name, image, likeness rights and their identity when those types of things can be easily copied using AI, and where under AI works that are created are not protected by copyright law because AI is not a human? There's a lot of risks in this space that we're going to keep watching. And so it's also a space that while we watch, we can contemplate in the brand ambassador agreements or the agreements with student athletes, so that there's not a situation where, again, there's not a win-win between the student athlete and the business. So that was the point of just bringing this up as something that we're going to continue to watch in this space.
Great, thank you so much, Clint and Erica. I am now going to open this up to questions. We did have one come through, and Clint, I believe this is for you. Are there opportunities open to high school athletes in North Carolina right now?
So that is a good question. That is a very topical question. It is currently being it's currently kind of a fight about it. The NCHS, the North Carolina High School Association, you know, a few months back promulgated certain standards related to NIL that would have allowed North Carolina high school students to engage in NIL beginning in the summer of this year. There's then been subsequent legislation that has passed that really transitions that from the North Carolina High School Association to the Board of Education and to public instruction. And so as of right now, that approval has not been granted, and so it's kind of in limbo. I anticipate it will be, and there will be some NIL opportunity for North Carolina high school students. But what was initially passed and put in place and expected to kind of come online in summer of 2023 has been held up as that legislation has worked its way through both the House and the Senate and the General Assembly.
Great, thank you, Clint. Also wanted to ask, we had another come through. Have there been many NCAA penalties handed down under the NIL?
I saw that one. I know that I answered it, kind of typed out an answer, but happy to address that, which is there is not. As of summer 2023, there are no known cases. There's no known penalties. I don't believe that there has been any this fall as well. There's a number of reasons, or at least guesses as to why that's the case. First of all, there is a new NCAA president as of March 2023. That's former Massachusetts Governor Charlie Baker. He replaced Mark Emmert, who towards the end of his tenure as NCAA president really backed off of enforcement actions after some high-profile defeats in court related to NCAA enforcement. What Charlie Baker will do and what his approach is to NIL and to NIL enforcement is yet to be known. He has just started, and so that will be interesting to see. Second, this is a guidance. There's a little bit less teeth to it. There's also a little bit of hesitancy from the NCAA, given that it's state to state. There's any federal legislation or specific federal guidance or regulation related to this. So the NCAA is hesitant there. Also, and I'd be remiss not to mention this, just in the last week, the NCAA has made it public that they're looking to kind of loosen some of the restrictions on member institutions. We didn't include that because we're not sure what that form will take, and it just came out in the last week. But the NCAA is at least looking at allowing member institutions to help with NIL deals from a facilitation standpoint. So kind of setting up a database of approved companies and people that can provide NIL services. To help with tax services for that compensation and those types of things. So if that were to pass, it certainly makes any potential enforcement even more tricky for the NCAA.
Great. And then we just have one last question, Erica. I don't know if you want to take this one in our last few minutes, but under the NIL agreements, what are the student athletes responsible for? What do they need to do in order to receive payment, or what are you seeing most often right now?
Yeah, I think for that, it's the social media engagement, the TikTok posts, Instagram, engaging with consumers in a way that promotes the products or services of the company that's paying. It's also public appearances, that also memorabilia, autographs, things like that. But finding ways that if the student athlete is already engaging with consumers, it can be a really easy way to tap in and have the marketing benefit from that type of engagement.
Great. Well, I think that is going to go ahead and wrap us up. Erica or Clint, anything else to add there? I wanted to thank you both for participating in this webinar today. Y'all are great coaches, if you will. And thank you for all of those in attendance. We had a really great showing today. Following this webinar, it'll actually probably be in the morning. You'll be sent an email with a recording of the session, as well as all of these slides for you to review and have. I'll send that out tomorrow morning as we do post it to our YouTube page. We are so grateful, Warden Smith. So grateful for your participation, and we hope you can utilize this knowledge today to embrace and enhance your business. That concludes today's webinar. Hope to see everybody again soon. Thanks.
Thank you.
Thank you.